Welcome to Monday, October 20th, 2008, Lowell Planning Board meeting. Tonight, we have a light agenda. We have no public hearing scheduled. We do have a matter under old business, which is 1782 Middlesex Street. The Lowell Planning Board voted to continue the public hearing for the project located at the above address during the July 21st, 2008 meeting to tonight's meeting. In order to provide the applicant time to pursue a zoning change for the parcel located at 19 Columbia Road. The board will review a request from the applicant to extend the continuance as they have yet to receive a hearing from the City Council. Redevelopment on the site includes 7,500 square foot commercial building providing 5 storefronts, each approximately 1,200 square foot in size. The parcel spreads 26 parking spaces over 2 lots, one with access from Wood and Middlesex Street, providing 18 spaces, and the other access from Columbia Street with 8 spaces. The project is located in the Regional Retail Zoning District and requires site plan review under section 11.4 of the zoning ordinance. We did receive a letter this evening from the applicant, Attorney Hall, who's representing the applicant, dated in regards to the petitioner, and the name is Basil Carantris, and the above address is located. Dear Mr. Chairman and board members, on behalf of my client, I hereby request that the above entitled matter that is scheduled before your board this evening be continued for an additional 60 days. I hereby agree on behalf of my client to the extension of the meeting and waive any rights that may occur on my client for the fact that this matter is not timely held. I filed a petition for rezoning for the property at the above address. The matter was referred to the City Council, and then it was referred to the City Solicitor's Office for drafting for proper notifications and description. The City Solicitor has yet to return the zoning petition to the City Council for a second reading, so that the petition can be sent to the Planning Board and the City Council. Once the City Solicitor has completed her analysis, I will request a joint meeting with the City Council and the Planning Board to determine the issue of rezoning in this matter. Thank you for your cooperation. Yours truly, Attorney James Hall. Aaron, did you have any chance today as well to speak with the Attorney Curtis, who's representing the applicant as well?
Yeah, I spoke with Attorney Curtis earlier today with respect to this request, and just confirmed with him that Attorney Hall had filed this letter with the office, with the Planning Board, to request a continuance, and he seemed okay with it. And just as he was okay just as long as something had been filed and had been presented to the board with a formal request. So.
Okay. So as we recall, as indicated, is when we're back here in the meeting back in July, we requested to give this as an interim date due to the fact that hopefully within the period of time that we allowed, that they'd have a chance to go before the board, put it down for a rezoning change, come back before us, have a vote on the zoning change, and we'd say we'd give it a date certain, so we'd continue the matter. So at this point in time, the applicant has followed through with requesting the zoning change. However, due to the fact that it has to be referred to the law department as it already has, and then it has to go back before the council, and the council has to vote to send it to us for the public hearing. So that's the timetable that we're waiting for?
Yeah, that's correct. And I spoke with Attorney Hall too last week just to confirm the timeline, and he indicated in his letter they have requested a rezoning change with the City Council. It's just kind of in a holding pattern for whatever reason. And as you know, typically you probably would have gotten a referral from the City Council by now for a recommendation. So for whatever reason, this is just taking a little bit longer to go through the steps.
Mr. Chairman,
sure.
May I ask a question? Who was sent to the joint public hearing?
Basically, in the past, we're usually notified by the council. And what they'll do is, a lot of times they'll either send it to us and we'll do a public hearing here, and then we'll make a vote, which is only a recommendation. And then that recommendation vote will be sent to the council for the zone change. Once in a while, they will ask that we hold it together. And if we have the joint hearing, what they do is they set us up on the table over there.
Right.
They come in, they have the public hearing. It goes to us first as a vote. We make our recommendation in favor or against. And after we give our recommendation, we do it verbally and we also do it writtenly. And then we pass it to the city clerk. The city clerk will announce it. We'll do it verbally as well. And then at that point in time, after we've made our recommendation, then the council can either act on it one way or another. They can act on it with conditions, without conditions. Usually, it's a zoning change, so they don't usually put conditions on it, but we cannot put conditions on it. And sometimes they'll act on it that night.
My question, Mr. Chairman, is because I've actually been through those
Right.
From the public side. I'm not a big fan of the joint public hearings. And who assents to that? Is it would we get notification from the city clerk saying this is the way it's going to happen through the request of the city council? Or can we as a body, and I don't know how everybody else feels, might be fine with it, would request that we would prefer to have a separate public hearing? And I understand the petition is asking this in the interest of time,
Right.
usually is the reason for it. I understand that. But,
In the past, we've just received the notice to come to public hearing. Have they ever, I don't think, as a board member, they never asked me my input. Whether they have the previous chairpersons, I don't know. But as a board member, we get a notice in the mail from the manager's office that there will be a joint public hearing this date and time in city council chambers at that date and time. And I know you've been at a couple before, and you spoke at a couple, and that's how we've been notified in the past. Whether we have an input on whether that, we've never had one to my knowledge. I mean, do we have a right to be heard on that? We could ask. But I know that usually we get the notice to come in for public hearing.
My preference would be that to have separate public hearings, but that's, again, I defer to the rest of the members as well.
Sure.
Yeah, Mr. Chairman, I'd agree if it's possible to have separate hearings. I think you're better off doing that because you have more of give and take with the public as far as that's concerned. I think what happens, though, is the time frame sometimes gets shortened up to a point where there's not time to have the planning board meeting and then have the city council meeting subsequent to that, because once it's advertised, you run into a little bit of a time frame problem. So that's sometimes the issue that comes up.
Any other further questions, Mr. Chairman?
Yeah, Mr. Chairman, thanks. Just to kind of recap where we are on this issue, this is the one where we had the development going in on Middlesex Street, and they were going to use the residential lot behind the development on Columbia Street
Correct.
as additional parking. And the neighborhood and people there had objection to the cars exiting and entering from the residential Columbia Street. So in an effort to try and create a solution where they could allow cars entering to the establishment off of Wood Street or Middlesex Street, they were going to go change the zoning so that cars could come in on that lot and then go park on the Columbia Street lot and not have an entrance or exit on Columbia Street. This was a proposed solution for that. So that's where we stand. The concern about this issue is, of course, this sounds like a good plan that is make everybody happy, and we have some of the abutters here. But the concern is that once the zoning change is made, since we can't put conditions on it, they can essentially legally do whatever they want on that lot. So it's a concern, something that I think hopefully the attorneys for the two parties can discuss and come to some agreement on. But we have no power, if I'm correct, in saying, yeah, we'll change this zoning, but you got to make sure you don't have an exit or an entrance on Columbia Street. We don't have that power. We can't put conditions on the zoning change. So when we get to the point where we actually have the city council refer this to a public hearing, and if we ultimately make the zoning change, that's an issue that I just want everybody to be aware of, and
If
that comes up.
Getting back, if the zoning change was allowed, then it still has to come back to us, the site plan. Okay, because remember how we did the site plan? Right. First, we allowed it, then the applicant came in and we withdrew it. So if this zoning change gets changed, if it gets approved or denied, either way, it comes back to us, the site plan.
Okay.
I remember, I think Attorney Hall indicated, if it gets denied, he's come back with the plan we've already seen. If it gets approved, he'll come back with the new plan that we tried to work out last time. So we
Sure.
would still have a say, we'd still have to have a public hearing regardless after the council meeting for site plan,
I see.
unless they totally withdrew it again. So we'd still have a say on the site plan.
I don't know if we'd have much legal standing to deny that site plan based on the fact that we don't want them to exit onto Columbia Street.
Yeah, I hear you
So,
that. You know,
I hear what you're saying.
Right, I mean, we still would probably get the same, would still be sent to all the department heads, and department heads all send back on common. And last time when we got it from the department heads, they said they didn't have a concern with the traffic there,
Okay,
which was
fair enough.
kind of alarming to a few of us, because we know it's a busy area.
Right.
But they were saying this additional work in that site alone would not impose enough traffic that it would have.
Additional traffic,
Yeah.
yeah.
Even though we know that's a tough area. It's one of the worst in the city.
Right.
So basically, so the request here is to allow more time as, to go, to try to see if they can still get the hearing for the extension for the public hearing. If the caveat is that the board is willing to continue it, we can also ask Aaron if they can ask, if there's any way possible that we could do the hearing here first, then go there.
I'd support that. I think that makes sense that
Do you have
we,
any problem speaking on that?
debate it here
Yeah,
first.
We say we have no problem with the continuance, but we'd like to have the own public hearing here, and if we get told otherwise from the power to be, so be it.
Yeah, I can absolutely look into that. If there's, I mean, I don't think there's any kind of time horizon that we need to worry about, since the applicant has voluntarily chosen to forego that, and it's reiterated in this letter. So as far as that, I don't think we're constrained in those terms. I don't know, as far as just protocol from city council, whether or not it's, if they make the call and that's that. But I'm more than happy to bring forward the concern of the board, and making sure that there's ample and adequate opportunity for public hearing, and making sure that there's two separate hearings.
Yeah, and I don't think it's necessarily protocol with the city council, because we've often had hearings where it comes to us first,
Right.
we make the recommendation, then it goes to city council. It's only when the time frame gets tight
Okay.
that they have to combine it. So if we put in the request that we can put it on a regularly scheduled planning board meeting, that'd be
I'd say, yeah,
best if
The
possible.
majority of times, it's definitely the twofold hearing process.
Right. Right.
Because I think, and sometimes, a lot of times, once, if we have the hearing here, some of the issues do get resolved before it goes before the council. Because
Right.
more things come out, especially with a plan like this, where we've had it reviewed several times here, and we've had several people that have been put on notice, have come, and then other people put on further notice and come back. So I think a lot of the issues are known to all to the applicant as well as the neighborhood people at this point in time.
Right.
And obviously, we'd give them the amount to speak here if they wanted before we went to the, for the zoning. So I'd have no problem with it here. Like I say, it's only been a handful of times that we've actually had I think one time, if I remember correctly, it was either the last time or the second to last time was when we were changing the zoning. And it was already advertised before the council, and they wanted to make sure we stayed on track, so they asked us to come in as well.
Right.
And then I think in one of those, when it came to the zoning, and then the other one, and went there, then and come back with the live-in relative apartments.
Okay.
We had it there, then it came back to us again later. Yeah, remember that one, that came in, and then it came back. Most of the time, it's only been a handful that were over there.
Okay.
So, I think they're asking for continuance for 60 days. Looking at our agenda, our next meeting in December would be December 15th. If we want to maybe continue to that date.
I make that as a motion to continue it to December 15th.
I'll second the motion.
A motion made, continue, so this matter will be put on for December 15th, '08. Aaron, if you could let Mr. Hall know, obviously, what the continuous date is. And
Absolutely.
actually put in a request, so if anybody's paying attention or watching at home, or any of the neighbors here, you can let them know we'll be back here on December 15th, '08 on this matter. Thank you. Moving along, we have a couple of other matters. We have notice from abutting towns. We have a couple of comments on, and actually some correspondence at the same time. I know we have one from NIMCOG here. I noticed that they have an update on relocation, they moving, Mitch? Chevy?
Yes, they are.
Where they trying to go to? I was reading it the other day, and I said, where they moving to?
They're going to be on Church Street,
Okay.
almost across from the VNA in the building over there. So they're just trying to finalize everything.
Across the street from the
Yeah.
VNA, right on there, yeah. It's good.
Okay.
A little more visibility and comfort.
Exactly.
Then I know a couple of things that we received something from the Development of Housing Community Development, talking about, was it gave a list to citizens and towns to see if they were the comprehensive permit, excuse me, was less than 10%. Obviously, I know we're more than 10% for the subsidized housing inventory.
Actually, I didn't include in your packets, because I didn't know if you'd want it or not. There,
I was just curious what our percentage was, if you know offhand.
yeah, it's 13.83% of the housing stock. So there's a total of 30, if I can find the last page here. 39,381 units in the city, and 5,231 are subsidized or income restricted. So that puts us at 13.28%. So we're, there's room there. That it takes a lot to lose 3% of that. It takes a whole lot.
I know, when I mentioned I was reading, I just had a note, I'm curious what our percentage was. I know we usually exceed it, usually no problem at all. Then another matter we got was from Mass Development. They gave us a letter on, and it talked about some project here. Is this related to a certain project that we have ongoing now, Aaron?
Revenue bond.
I saw something on Varnum Ave, but
There's nothing that we're working on right now that's been before the board. This is, I think, for a bond issue with Mass Development for this 501c3 company or organization, Justice Resources Institute. And they have looks like a capital improvement program that they have going on for several locations, one of them being on Varnum Ave in Lowell. So I think that's why we're getting the notice.
okay.
And
King Street.
doesn't exactly say exactly what the capital improvement or what's going on for the Lowell location. It doesn't get that specific. Some of it's paying some past bond debt down, so I don't know exactly what the project is, but.
Okay, thank you. Moving along, I believe at this point in time, we have the zoning board of appeal notices, and these are matters that come before us as a recommendation to the zoning board of appeal. I believe we have 2 matters in our packet. The first one we have down is Bank of America, which is 724 Chelmsford Street. And this is in a high-rise commercial district. And the present use is a shopping center. And the proposed is for a new bank facility within the shopping center. They want a special permit to put an internally illuminated sign and variance to extend the non-conforming sign. Relief needed for operation of business. Signage is important to customers.
Nice one.
I believe they have a copy of the sign. This is out on Chelmsford Street there with a New Mateos Stairway Plaza put in. They do show a copy of the old sign and the new sign. They look pretty similar. So I don't know if they add into the sign a little bit, appears to be. Size-wise, I can't tell if the old one's
One of
the
these
same
is
size.
old and one is new.
Yeah. There's the existing one up there now. There's the existing one.
Which is this one?
The top right there.
Oh, okay.
And this is the proposed, so it looks like, the cement,
All right, I missed that.
yeah.
Maybe it's the internal illumination that's a change.
Yeah, I think that's what it is. This is,
Mr. Chairman, both of these matters are sign issues. Would it make sense just to refer them both to the chief design planner that reviews our signs to make a recommendation?
okay, so on,
Put that in the form of a motion.
sure, on the Chelmsford Street, 724 Chelmsford Street is a sign. Motion made to refer to the sign planner.
I'll second that, Mr. Chairman.
The other one I'll just read into record. This one is also a sign. This is at 11 Wood Street. This is for Papagino's. Replace faces of existing wall and pylon sign cabinets. Install a new set of channel letters. This is Papagino's, which would be up on the,
Wood Street.
up on Wood Street where the Market Basket presently is now. And there's a motion by Mr. Ginman that also be referred to the design planner, site design planner.
I'll second the motion.
Motion made and second, those matters. Those 2 matters are referred to the zoning board of appeals for public hearing. Moving along under general correspondence. Aaron, do you have an update for us on a matter or 2?
I've actually got a couple of things here. I'll pass down a pamphlet. There's an event going on tomorrow night at the National Park, auditorium, pass it down. They're doing a film screening, the Lowell Green Building Commission, in collaboration with I guess, a newly formed Lowell Film Collaborative, are showing a documentary called The Greening of Southie. It basically documents the construction of the first LEED certified residential building in Boston. And I have yet to see the documentary myself, but apparently it's kind of a no-holds-barred discussion of green building and kind of the nuts and bolts of it. What's interesting about this is that after the film showing, there's 3 individuals there that are going to hold a discussion and a panel. One's Hank Keating, who's principal of Trinity Financial, who's working on the Hamilton Canal District. They've done some projects in Boston that have been LEED certified or certifiable. The project manager for the project in the documentary, the McAllen Building, is going to be there, as well as Ken Kerneef, who is a principal of Nobis Engineering in the city of Lowell, who is currently, they're constructing the first LEED certified building in the city. So we have some people here to discuss specifically the challenges to getting to LEED certification and in green building in general. So I think a pretty interesting opportunity to dive into that subject. So I would encourage you, if you can make it, to go, and anybody who's here in the audience or watching. It's, I think, going to be an interesting discussion into the whole green building realm.
So this is at the Lowell National Historic Park Visitor Center on 246 Market Street.
That's correct.
Tomorrow night. We expect students at 6:30 and the film starts at 7.
Mhm.
Gets over at 8:15, panel discussion, then questions and answers at 8:30.
Yeah.
Thank you.
And then, last but not least, I'll hand this down. You may be aware that the land court had filed the decision for the project at 219 Westview Road. This goes back to a denial of a subdivision and a planned residential development. So I wanted to hand out that decision to the board for your review. The land court judge essentially affirmed the findings of the planning board on every single element for denial, including the fact that their project did not meet the master plan, elements of the master plan. One being that the master plan outlined the preservation of light industrial zone land to be preserved for light industry. And obviously this project was proposing residential uses. The second half of that, and I think one of the things I wanted to highlight to you, and George Proikis wanted me to highlight, you actually can find on page 14 and 15, was with respect to neighborhood character. And the land court judge in this case affirmed the criteria in judging and issuing a special permit on the basis of neighborhood character. And that an interesting line here on page 15, that and the second denial that the planning board made with respect to this project dealt with most of the requirements of section 11.3, and that although neighborhood character may be an indefinite term, it is not too vague to be enforceable. So basically, the judge, I think, was just affirming the idea, the concept, that neighborhood character is a criteria that the board is able to make a judgment on case-by-case basis, particularly with special permits. So I just wanted to give that to the board for you as we see more projects coming in. I think it's important for you to understand that there is some backing from the courts on holding the line on some of these issues of neighborhood character and design.
So obviously, their argument was that neighborhood character was too vague, and by us trying to pinpoint it down and making our decision, so basically, when we vote in regards to neighborhood character, we really gotta try to give a punch list of what the neighborhood character is to help us in cases like this in the future.
That's right. They actually cited a case called the Castle Estates Inc.
Okay.
versus Park and Planning Board, where that case, basically said that, a board
Back
cannot.
in 62, too. You don't have as many neighborhood character cases back in 1962.
Yeah, I know, huh?
I thought you'd have a more recent one, if they were gonna,
Yeah, but
Wow.
it goes back, I guess they were a little forward-thinking, I guess, but,
yeah.
you know, basically, the standard was that, you know, you couldn't reference something that wasn't in a bylaw or in the zoning code, or something that was so vague to be unenforceable. But like you said, as long as we're looking at each project and we're being specific, that neighborhood character as a criterion is absolutely applicable in making a decision to deny a special permit.
Yeah, because this was under advisement by the judge of the land court for a long period of time.
A couple of years.
Yeah. And usually, they don't go that long. I mean, usually, even 6 months is usually, you know, anything beyond that's usually kind of a long period of time. Would you agree on that, Joe? Usually land court for 6-month period, usually have a decision back?
Yeah, usually it's
mean-
much quicker than that.
I mean, 2 years usually when a judge makes a determination. I know there's been inquiries as to this, and when we've talked to law department and things in general in the past, I've always said, what's the status of this? And they said, we're still waiting to hear. Yeah, so I'm glad you brought it to our attention.
Yeah, it came down early this month, but,
Yeah, I think it was, law department got October 7th.
yeah.
Received law department, city, they stamped it in.
But as I said, each element of denial was affirmed by the land court judge.
So our decision holds, right?
Yeah, exactly. Oh, yes, firmly.
Yeah,
Um,
I know we denied it, yeah. And then it came back before us a second time, I think that's here somewhere. Right. First time we met, and then the second time we were in the mayor's reception room.
Yep.
Because the
And-
council was doing budget meetings in here.
all right.
That's right, the second time we were across the hall.
We had enough of them on this.
Yeah, they came back and we went across the hall. We had it scheduled, when they brought it back, they brought it back to see if we could, I forget if it was a request back from the land court or the lawyers agreed, I get the details. Then when it came back, we opened up again and had all the testimony down there because it was during budget session. And that's why the council was in here, so we were down the hall. All right. Okay, thank you, I appreciate that.
Interesting.
Okay. Anything else that you have for consideration?
That's all I have for today.
Okay. Any board members have any correspondences or any information on the dates or anything? If not, okay. Hearing none, I'll entertain a motion to adjourn.
So moved.
Move second, we have adjourned. Thank you, good night, everybody.